All right, hello, outdoor industry law class. I'm back, and this is video that will accompany session 4, covering chapter 6 in the book, which deals with statutes affecting the outdoor industry. The statutes that are covered in the book deal with those types of statutes that limit liability for a particular industry. And I'd like for you to think more broadly about that. So I'm going to share my screen here and go back to our outdoor industry, or excuse me, our stakeholder model, and take a look at this. If you think about rules and regulations, whether they're federal statutes, state statutes, local regulation, often in the form of land use regulations or regulations issued through your county commissioners, or even city ordinances, those are all obviously laws that affect your operations. So in addition to these statutes that limit liability, I'd like for you to think about the other statutes. I'm going to primarily think of federal and state statutes that will affect your business and your operations. This will be of value when in your final project, because you'll identify certain risks that are going to be impacted by the statutes that relate to that particular risk. So it's really not that complicated. If you think about it, we have our business. We talked about what kind of business are we going to form. Well, if you decide you are an LLC or you're a corporation, then you're going to have statutory requirements to maintain the protections you get from those entities by virtue of operating as such. So in other words, you have to comply with the Colorado Corporations Act if you are going to operate under the auspices of a corporation. So you need to check the statutes in your state that help you maintain your entity existence. That's one area. And those you find in the Secretary of State's website and office, along with the statute that the under Colorado Revised Statutes, which is the has to do with the Corporation Act. So that's the businesses. And then you start thinking of your other risks. And let's go to employees. That's a risk that's easily identified, and you can look to the federal law, the Title VII laws of the Colorado the Civil Rights Act of, what was it, 1964. You can look at the various employment laws in Colorado dealing with employees, and the Colorado Civil Rights Commission is the regulatory agency under responsible for enforcing those laws. And then, of course, on the employment side, on the federal side, the EEOC is the regulatory authority. So for each one of these statutes, you're going to have an agency that issues regulations to enforce those statutes. So, and you can think of safety, OSHA, and related statutes that will apply to your particular business, statutes and regulations as it addresses employees. Competitors, you may decide that one of the issues is going to be intellectual property. So you may want to look at the uniform, let's see, what is that one called? It's the Uniform Trade Secrets Act, and it's been adopted by every state, has its own. I say every state, sometimes I make a caveat for Louisiana, since it's part of the Napoleonic Code. But in any event, check to see what Uniform Trade Secrets Act, what protections that might give your business related to intellectual property. Along with competitors, you'll need to think about antitrust laws, that federal antitrust laws and regulations associated with that. Customers and vendors. Those, you'll deal with all types of statutes and regulations with your customers and vendors. It may be that it's the food and drug regulations. It could be that it has to do with the statutes we talked about, the Uniform Commercial Code, when dealing with customers or vendors in the buying or leasing of goods, and the warranties that go along with those types of activities and statutes. Maybe the Magnuson-Moss Act, some of the consumer protection laws that are out there, the labeling laws that may be in your states, and that deal with what has to be on labels for particular types of goods. So, and services. So be looking at those types of laws as well. Your owners, there I'm thinking of securities types of laws. You know, what are the disclosures that need to be made, and the regulations around that. I think you all touched on a really important risk factor that isn't directly related to securities law, but looking at how you maintain the support for your nonprofits, and what type of risks are associated with that. Some of those may not be statutory, but they sure may be contractual as well. So again, looking at what regulations and statutes may be involved with dealing with owners of the business. Land and landowners. We know that, for instance, the Colorado Premises Liability Act is one that deals with the obligation of a business entity, an entity that invites persons onto their property for business purposes, and what are the legal liabilities associated with that relationship. There will be, when you talk about land as it relates to use of public land or leasing of public land, there will be all types of rules, regulations, and statutes around dealing with the National Forest, the BLM, and other public land administration, Colorado Public Lands, and the agencies that deal with those. Wildlife, I mean, we can go on and on. So it won't be hard to find statutes and rules and regulations that may address a risk associated with your business. Creditors, that's a little different. There's some creditor related laws that may give some protection to consumer creditors and that sort of thing. There are a lot of statutes around if you happen to be a creditor that is like foreclosing on real property. There's really a tight statutory construction that we have in Colorado to accomplish foreclosures or to replevy personal property and that sort of thing. Again, government and community, I would think there will be regulations like crazy dealing with your business in those areas, whether it's again dealing with land ownership or use, or providing consumers with goods or services. So again, I just started with this. I wanted you to be thinking outside of the box in terms of just those types of statutes that limit liability as they're discussed in the book. So with that, let's go into our week 4, and I'll share again. All right, there's week 4, and let me go through just quickly the assignment. One reason I started out the way I did is one of the assignments will be for you to find at least 2 state or federal statutes or regulations or local county regulations or city ordinances that may affect a risk associated with your business. It should not be difficult at all. Describe what risk will be affected by such regulation or statute. Just start with 2, but I would suggest that you really start a list of those that you may want to look into for your operations, not only for your final project, but more importantly for operating your business. The other parts of the assignment, there is one to review the Michigan Ski Safety Act, the Colorado Ski Safety Act, and compare the Anderson case versus the Cunney case. You can read the assignment. In response to a question anyway about length, I want to have that assignment not exceed more than 2 paragraphs. Then I want you to all read the Bear versus Crested Butte case, and you can see what that discussion's about. Again, not more than 1 concise paragraph, and then reading the Bellegarini, however you say it, Running Elk Corporation case dealing with the New Mexico Equine Liability Act, and again, 1 concise paragraph on that. So you guys can read the assignments. So getting back to the issue around the statutes that are covered in the book, let's just talk about some of those. And again, this will be a brief video because you will obviously be reading the statutes and reading the cases. But let's just use the Colorado Ski Safety Act as one example. And the way these statutes are structured are to define the duties of the operators and then the duties of the customers or the guests. And in so doing, they will establish what obligations the operator has, for which there would be what we would call, as we talked about last week, hopefully, negligence per se. Since if a ski operator doesn't put the appropriate signage up, then they will be liable despite the protections under the Colorado Ski Safety Act, because it is an obligation that's imposed on them by the Ski Safety Act, and it would be negligence per se. And the reason we say per se, it's because of a violation of the statute that would impose liability. So that has to do with the duties of the operators. Now, duties of the guests and customers, not to ski in a reckless manner, not to be intoxicated. And it has duties as it relates to the operator's obligations in running the lifts, which are in part governed under the Tramway Act as well. And you'll see strictly what those obligations are on behalf of the operator. And then likewise, as it relates to the duties of the customers, there are duties that relate to their obligations in loading and unloading and using the lifts, and then there are obligations in how they conduct themselves as they ski or ride. So it's kind of broken down into those 2 areas because there are 2 different types of liability structures and contained in the Act, and incorporating the Tramway Act for operation of the ski lifts. So once you get through the duties and the obligations, then you kind of focus on what are the inherent risks of the activity. And in Colorado, you'll see a real detailed list of the inherent risks associated with skiing. And we'll go into that much more when we look at the specific industry of the skiing industry later on in the chapter. So I don't want to steal all our thunder for that discussion. But in any event, you look at the inherent risks, and to be very general, the ski area is free from liability for injuries associated with those inherent risks. Now keep in mind that's different than if a ski area fails to do what it's obligated to do in operating the lifts or putting up signage, which are the primary obligations that are imposed on the ski operators under the Colorado Ski Safety Act. So what we're saying is that, but as it relates to the inherent dangers of the activity of skiing, then the operators do have protection and have their liability limited for those types of inherent risks. And you can read through all those, and we'll have much more fun with those when we start talking about ski areas specifically later on in the course. There are other ways that ski areas are protected in the Skier Safety Act, and that is by imposing limitations on not only the type of suits that can be brought, in other words, suits for the inherent suits for injuries related to their inherent risks of skiing may be prohibited under the Act, but also if there is a action that is permissible under the statute, often these statutes and also the Colorado Skier Safety Statute as well has a time limitation in which the lawsuits can be brought. And that may be different than the general, what we call statute of limitations, that may be applicable to negligence and tort actions in general. So like under the Colorado Skier Safety Act, I'm looking at statute of limitations has to be brought within 2 years. That's 33-44-111. 33-44-112, notwithstanding any decision, etc., no skier may make a claim against or recover for a ski area operator for injury resulting from any of the inherent dangers and risks of skiing. So there's the specific incorporation of limiting liability for those inherent risks. And then this is a big one. There's a limitation on the amount of money that can be recovered under actions brought against the ski areas under these acts. And you can read for yourself, but the injuries associated while riding on a passenger tramway, or let's see, well, just in general, a $1 million limitation with different present value amounts depending on whether it's based on whether the damages are based on expected loss of income or expected medical expenses, so that you put a present value back on some of those. So there is a provision in here which basically allows the court to exceed the maximums when it deems that it's unfair, primarily as it relates to present value of future medical care. And so that's a really important issue or benefit of the Skier Safety Act, and those that provide some limitation on liability protection is also the limitation on remedies. In other words, the limitation on the amount of dollars. I'm going to pause for just a minute. All right, I'm back. The other thing I wanted to cover as we talk about these types of statutes that limit liability for particular industries is that, much like releases, they are very strictly construed. Courts do not like when persons give up or are obligated under statutes or releases or whatever to give up their rights to sue and have their day in court. So these statutes are very strictly construed, and you'll see that when you start reviewing the cases that are in the book, as well as when we get into some other specific cases later on when we're dealing strictly with ski areas. But again, the general rule is that they will not be expanded beyond their intent, and that what we call a rule of statutory construction, which deals with how courts look at statutes, will be applied very, very strictly. Some of those rules of statutory construction are when there is a list, for instance, of inherent dangers, that if that list doesn't include a particular list, a particular item, then the statutory construction and rules of construction for the court is that it was intentionally left out. That's why you'll see language, including but not limited to, and that sort of thing. But there again, you have to be careful that that's not overly confusing to the party that is waiving their rights. So in reviewing the statutes and also in reviewing the cases, keep in mind that that is the kind of the general way that courts approach these types of statutes that deal with exculpation and that sort of thing. So with that, I am going to conclude this video, and will rely on you all to obviously read the case, read the statutes that are there, the cases, and do the assignment, which helps you to analyze those cases. But I think more importantly from this, I'd like for you to start exploring the additional laws and regulations that will affect your business, and start doing some research, start getting some of those together as it will relate to the final project, and more importantly, successful operations for your business. So, and again, part of the assignment is just identifying two of those and describing what risks they might affect. But I really encourage you just to think outside the box. Just start looking at every one of your potential risks and jot down what that risk might be. And I know you've started that, and then start thinking about, okay, what law might apply, and in what form does that law appear? Is it going to be a federal statute? Is it going to be a federal and state statute? Will it likely be, maybe something that's just protected under common law, judge-made law? Or, and then where are the, if you find a statute, then you're going to find an agency that's going to enforce that statute. And where do you find those regulations, and what are those regulations, those permitting requirements, and that sort of thing. So with that, I think I'm going to sign off, and I will see you Wednesday.